Hey, folks! Laura Owens case. The case that keeps giving. In the bankruptcy case, her attorney in the civil case, David S. Gingera, filed a he filed a motion to appear for Laura Owens in a limited capacity. And it was an interesting read. And before I got the chance to record it, the reply from the creditors showed up. So I'm going to read that instead. Oh, you're going to love this. You're absolutely going to love this. Let's see here. Dun, dun, dun. Where is it? There. I knew I had it. Okay, let me position myself up here to start with. You can't see that. Hold on. There. Irene J. Lashinsky, Jennifer A. Giamo. Okay. Now I go up here. In the United States Bankruptcy Court for the District of Arizona, in regard Laura Owens, debtor. The United States Trustee, UST, by and through undersigned counsel, files this objection to motion for leave to enter limited scope appearance, docket 37, filed by David S. Gingera. Folks, sorry, it's my pronunciation. English is not my first language. This is a hard name to pronounce for me, so I do the best I can. But David S. Gingera and respectfully submits the following memorandum of points and authorities. Debtor Laura Owens filed her voluntary Chapter 7 bankruptcy petition in this case on December 8th, 2025. Debtor filed her petition pro se, and no attorney has entered an appearance on her behalf. On February 9th, 2026, debtor appeared and testified at a continued meeting of creditors pursuant to Bankruptcy Code 11 U.S.C., section blah, 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 blah. The UST briefly examined debtor under oath at the 341 meeting. During the examination, it became clear to the UST that a more extensive examination pursuant to federal blah, 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 blah would be necessary. Accordingly, after the meeting concluded, the UST filed a motion to obtain documents and examine the debtor pursuant to Rule 2004. The court granted the Rule 2004 motion on February 12th. On the same date, Attorney Gingera filed the instant motion for leave to enter limited scope appearance. The UST now objects to that motion for two essential reasons. One, the local rules strictly prohibit the limited scope appearance that Gingera requests. And two, Gingera is disqualified from representing the debtor based on conflict of interest. The UST has no objection to debtor's retention of counsel. The UST only objects to the limited scope representation that Gingera proposes. 1. There is no legal basis to disregard local rule 9010 blah blah blah, which states as follows. An attorney who files a debtor's bankruptcy petition or who files a notice of appearance on the debtor's behalf must represent the debtor in all matters other than adversary proceedings until the case is closed or the court enters an order approving withdrawal or substitution of counsel. Local rule, the 2018 notes to the local rule state that, quote, the court will enforce this obligation regardless of any limitation contained in any retention agreement between the attorney and the debtor. Despite this firmly established rule, Gingera asked this court to allow him to, quote, provide some legal services to debtor on a pro bono basis, but not without any pre-established limits. See motion to appear. He seeks permission to represent. Oh, darn it! I covered that. Well, you heard it anyways. I'll go here. You can still see it, I hope. Let me make it bigger. There. I don't want to go back and re-record this. He seeks permission to represent debtor for 60 days with the option to continue that representation in his sole discretion. Yeah, folks, that is David Gingera putting the cart before the horse. David S. Gingera wants the court to allow him to recuse himself before he enters. Sorry, folks. It's so stupid. Yeah. Significantly, Gingera will not unconditionally commit to represent the debtor for a full 60 days. Rather, Gingera states, quote, if the amount of work required by additional discovery request from the trustee or any creditors becomes excessive, undersigned counsel may terminate his representation. Now, Mr. Gingera must have balls this big to actually ask a court to allow him to make his own rules. Now, yeah, he might have brass balls, but he also has a knuckle head. It's bad. Local Rule 9010 was specifically designed to prevent precisely the type of limited scope representation that Gingera is proposing. The reason underlying such a rule was best explained by the court in Inresiare, Banker the NEV 2013. Lawyers cannot indiscriminately dismiss clients at their whim, or even if their clients don't pay on time. Lawyers are professionals that owe fiduciary duties to their individual clients and must continue to represent them even if initially rosy predictions turn sour. Moreover, allowing Gingera to enter a limited scope appearance would needlessly complicate the process of obtaining stipulations, exchanging documents, and communicating about various aspects of the debtor's case. For example, it appears that Gingera's proposed limited scope appearance would not cover issues pertaining to adversary proceedings. The UST's investigation of the debtor is for the express purpose of a potential adversary proceeding under Code Section 727, as stated in the UST's Rule 2004 motion. Would Gingera be responsible for stipulations pertaining to adversary proceeding deadlines? If not, would counsel for the UST be required to communicate directly with the debtor with respect to some, but not all issues in this case? The confusion as to what issues Gingera will be handling and for how long he will be appearing is too burdensome to justify the requested deviation from Local Rule 9010 1C1. Gingera offers no compelling factual or legal basis to wholly disregard the firmly established local rule prohibiting limited scope appearances. Therefore, the court should reject Gingera's request and hold that Gingera must either enter a notice of appearance subject to the rule or not appear at all in this case. Now, had they been... This would have satisfied the court saying, yeah, you have to choose either or. Either you're in or you're out. The in, out, and not in the way Laura Owens prefers. Let's continue. Gingera has a conflict of interest. Oh, hell yeah, he does. Because as you remember, she threw him under the bus in the hearing that I covered on my channel regarding the affidavit she signed under oath that turned out to be complete bullshit. Either she lied under oath in the trial or she lied in the affidavit. It can't both be true. And she threw Gingera under the bus by saying, well, he authored it and he signed it on my behalf. Oh, really? And you claimed, Laura, you didn't read it carefully? Yeah. And you said that under oath. So are you perjuring yourself again? Or did you tell the truth, making Gingera more or less falsify a record? I'm good with either of those choices. Debtor's largest creditor in this case is Clayton Eckert. The debt owed to Eckert arises out of a paternity suit filed by debtor against Eckert in state court in Maricopa County, Arizona. The paternity suit. During the course of the paternity suit, debtor testified under oath and filed a sworn affidavit regarding her financial condition and income. At the meeting of creditors in this case, debtor was questioned about a particular affidavit filed in the paternity suit in which debtor attested to owning a financial account with over $450,000 of funds. Here it is. In response, debtor testified that Gingera could explain the circumstances of that affidavit and offered to allow Gingera to testify at the meeting of creditors. Footnote 1. The UST in the process of obtaining a transcript of the 341 meeting. Oh. In light of the foregoing, Gingera is a potential witness who, according to debtor's own sworn testimony, has personal knowledge of highly relevant information concerning debtor's sworn statements regarding debtor's assets and income. Unquestionably, such information is material to this bankruptcy case and directly bears upon two crucial issues. One, whether the debtor in fact had assets and income that have not been disclosed in this case, and two, whether the debtor made a false oath in this case, or alternatively, perjured herself in the paternity suit. Yeah, folks, this is not one of the charges in the criminal case against Laura Owens. So they might just have handed, depending on the outcome of this, might add another count of perjury. Rule 3.7 of the Arizona Rules of Professional Conduct, which applies to attorneys appearing in court pursuant to Local Rule 9010-1A, prohibits a lawyer from acting as an advocate for a client in a case in which the lawyer is likely to be a necessary witness. Footnote 2. The lawyer may act as an advocate despite being a potential witness only if 1. The testimony relates to an uncontested issue, 2. The testimony relates to the nature and value of legal services rendered in the case, or 3. Disqualification of the lawyer would work substantial hardship on the client. Yeah, none of that applies here. In light of Gingera's knowledge of debtor's sworn statement pertaining to her income and assets in connection with the paternity suit, Gingera is a potential witness and therefore disqualified from representing the debtor in this bankruptcy case. Wherefore, the UST requests that the court sustain this objection and deny the motion to appear. Now, they could have added one point here, the one I discussed earlier, with this signage and everything. They could have added a lot more. But they were satisfied with the rule, and he's a potential witness. And it doesn't really matter what the court does. They have to disqualify him based on this as an attorney. And still, the facts remain. Laura Owens either lied to the bankruptcy court or perjured herself in the paternity suit. So it's either another count in the state criminal case, or it might lead to, and this I believe will happen, a federal case against Laura Owens. Yeah, Laura, when you filed for bankruptcy to hide assets and stuff and money from Clayton, you went from a big and serious fire into the hands of the government. Laura, has nobody told you you don't fuck with the IRS or the bankruptcy attorneys? Because neither of them cares about you. You're crying, you're moping, your supposed illnesses do not matter a single bit. So you're screwed either way, because you can't stop lying. And as you all know, big surprise, Laura, the boys are fighting back.
Laura's got a secret, oh what a tale. She spins a wild story, sets sail without a sail. Fake baby bumps, she's got tricks up her sleeve, but the boys see through it, they just can't believe. Oh Laura, 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 what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise. Points her finger, you're the bad guy now. But truth's got legs and it's taken a bow. Her plans unravel like a thread on a spool. Life's not a game and you're breaking the rules. Lies and lawsuits, so what a show. But justice is coming, it's starting to grow. You can't win hearts with tricks or a fight. The truth shines brighter than a starry night. What's true, life's much